It is August 22nd of 2026, and this is the Court Gallery. We kick things off with a wild apartment dispute featuring accusations of stolen packages, dog attacks, and a standoff involving a BB gun. Will the judge grant a protection order? Then we pivot to a zoning battle where an unrepresented defendant might actually have the ultimate trump card against the township. Later, we head to Kansas for a drug sentencing complicated by an impromptu road trip to Oklahoma that resulted in even more charges. Finally, we wrap up with a defendant trying to withdraw a guilty plea, blaming his sudden change of heart on blood pressure medication and sleep deprivation. All that and more starts right now.
Bangs and Marquita O'Neill.
Hello, Your Honor.
Good morning.
Good morning.
If you would both raise your right hands for me, please. Swear that testimony in this case will be the truth, whole truth, and nothing but the truth.
Yes.
Yes, Your Honor.
Okay, thank you. And Ms. Bangs, Ms. O'Neill is a neighbor?
Yes, Your Honor.
Okay, and there's a dispute going on between the two of you. It sounds like that in your statement, Ms. Bangs, you indicate that Ms. O'Neill displayed a firearm towards your apartment.
Yes, Your Honor.
And has blocked your car in.
Yes, Your Honor. This has been going on since February.
Okay, and what started it? What do you believe is underlying these actions?
So in February, I got a package sent to my house, and just due to the surveillance evidence, they were the only person that could have stolen my package, and so I confronted them about it. I got mixed answers from.
Hey, let me interrupt you. Sorry.
Yeah.
Them. So it's Ms. O'Neill's in front of me. Is there somebody else involved as well?
So it's basically the adults in her household. So it's O'Neill, Amber Butler, which is her daughter. I confronted both of them about my package being stolen. They both gave me two completely different stories. I contacted the police. I filed a report. And since that point, it has been absolute chaos. I have been dealing with multiple incidences of their violent dog being unleashed and attempting to attack me and my daughter, Kaylani. There was an extreme violent incident that happened where my daughter was choked to the point to where her esophagus was cut of airflow. And that in itself caused multiple months of behavioral issues in school and at home. They are constantly monitoring my home with their recording devices after management has told them several times to not direct their door cameras towards my home. They have blocked me in several incidences from February to now to where I cannot come and go. And management, again, has informed them several times that they cannot do that because, one, it's a hazard, and as well, we have multiple different parking spots that they could park in. And then the gun situation happened twice, and it's like, it feels to me that it is getting to the point where it is genuinely getting unsafe. Like, it's funny to them. They think it's funny to scare me. They think it's funny to make me bombard myself in my home. I barely leave my house. I only leave my house if I absolutely have to because of this situation. I feel like I'm being bullied. I feel like I'm I'm powerless in the situation when it comes to me and my kids. And I already have a history of domestic violence, and the things that they are doing are repeat situations that I've already been through, and it's put me in counseling because it's reflaring my PTSD up. All I want is to be able to come and go in my house. I would like to not be in fight or flight constantly, and I want to be in a stress-free environment as much as possible, just due to the fact that I am a high-risk pregnancy at this very moment. Um, I don't want people tampering with my car again. I don't want people pouring urine and odd substances on my porch. I I don't want to deal with gun violence or unpredictable behavior because they think that they can do things to me and get away with it. And as time goes on, being that these situations are becoming more and more violent and they're not reaping any repercussions for it, I really do feel like I need a protection order at this point.
All right. So you said your daughter Kalani was choked,
Yes.
and who did that?
One of Mrs. O'Neill or Miss O'Neill's grandsons, I believe his name was Xavier. He's around the same age as Kaylani.
Okay. And did you report that incident to law enforcement?
Yes, Your Honor, I did.
And what did they do? Do you know?
Because he is under the age of, I believe, 11, they said that they couldn't do anything legally about it, that all they could do was talk to the family um, about his behavior, and that was it. That's all they said they could do.
Okay.
But what is concerning about that situation is she was choked from behind and she was pulled off her feet. And my daughter started describing to me about the things she was feeling, and I have been choked by partners, and I know what it feels like to have your airflow completely restricted like that, and to hear my own daughter tell me that she was feeling those things is sorry. It's just really hard. It's really hard because she's only 9, you know? My apologies. I'm so sorry. I really am trying to keep it together, but this is a really hard situation for me because I'm trying to get out of it and I feel like I'm not having any sort of solution.
So you live in the same apartment complex?
Yes, Your Honor.
Okay. And what's the landlord say?
The landlord is working on removal due to the severity of these situations. Every party involved, including like programs, involved in this situation, allegedly have been taking this serious, and they've moved it up to um their in-house lawyer or attorney about the situation because the guns are now involved and there has been shown aggression, intimidation, and attempts to commit violence. I mean, that I would consider that that's violent.
Okay. So as far as the weapons, tell me what's going on with weapons.
Um, the weapons in terms of July 20th when she came out and pointed this gun at my door and then continued to trace it down the wall. Um, I I can't tell people they can't have guns, but when you are pointing it at my home and you have already been harassing and doing things to me that are making me feel unsafe, I would think that that is intentional. And then the second situation with the sorry, go ahead.
Where was she standing when she did this?
She was standing, but like she was walking because we have a ramp. She was walking down the ramp, like she was about to start walking down the ramp. So she was walking down the ramp, like parallel to walking down the ramp, but she had the gun at a 90-degree angle pointing it at my house.
So how far away was she? Just give me an estimate.
I would say maybe 4 feet from my door.
4 feet, as in she could almost reach it with her arm?
I would think so, yeah, because our homes are at least like her door is directly in front of mine, across from mine, and it's about maybe a 6 foot space.
Okay, so she was leaving her apartment or going to her apartment?
She was walking out of her apartment towards the entrance of the building.
Okay, and you were outside, you were inside, you saw her through a window, you saw her in person. Tell me about
No,
that.
I was in my home and my door camera went off. That somebody was at the door, so I checked it.
Okay, so what you saw is what you saw through your door camera.
Yes, Your Honor.
And what did Ms. O'Neill do? Did she pointed the weapon at your door?
She pointed it at my door and continued to point it down the wall because how my apartment is set up is you have the front door, which leads to the living room. And then as you walk down the wall of the building, my room is right underneath the staircase. And that's where she continued to aim it, was down to my room.
And then what did she do?
I she just did that and then walked out to her car.
Okay. And was she alone? Was she with somebody?
She had a male with her. I'm not entirely sure who that was. I couldn't figure out who it was, but she was with an unidentified male.
And did you report that incident to law enforcement?
Yes, Your Honor.
And what did they do about that?
They said that because she didn't verbally say she was going to shoot me, that they couldn't do anything about it.
Did they see the video of it?
Yes, Your Honor. They have the video and pictures of it.
It was Lacey Police?
Yes, Your Honor.
Okay. All right. You said there was a second incident involving a firearm. Tell me about that.
Yes, on the 22nd of July, 2026, her daughter Amber Butler was walking up to her door and she started waving this gun. It I believe was a toy gun, but it was the message because she was cocking it up and down in front of my door camera, and then she walked in the house. And it's like management had already spoken to them about the first incident immediately because it involved a gun and that's a serious situation. So they were fully aware that that was already being documented, and then they doubled down on doing it a second time but used a toy gun, I feel, to relay the threat but to not be held accountable for the action because it is a fake gun.
Yeah, and how old do you believe Amber is?
Maybe 40s, mid 40s, maybe.
All right. Ms. O'Neill. Go ahead.
Okay. I want to first say that I am visually impaired. Your Honor, I have wrote everything down because I'm kind of nervous, so I want to explain the situation with Miss Anicia and the allegations she made about me. When she talks about a gun in her statement, it was a BB gun. My grandson is 16. He's allowed to want to play BB guns, so I got a BB gun and we went to the field over where we stay at. There's a field right there where we went and shoot at the tree with our target. So I felt that there was no harm in doing that. Talks about I pointed the gun at her. I never once pointed the gun at her door. If you see me on her statements, she has the same picture twice, and I was going down the walkway. I was going this way. with the gun in my hand in this hand. So there's no way if I was gonna turn, I'd be this way or like this with my hand. So I was not pointing a gun at her. There was no unknown male. She knows my grandson. I've been living there over a year. So she knows my grandson and she knows that he lives with me. Yeah, I seen the photos. For months, Anicia and her children have been harassing me. I haven't been really saying anything. I haven't called the police or anything because I just ignore it. I just want to be left alone and live my life, I think where all this began was because I said, I didn't want to watch your kids no more. There's nobody at my house, her kids' age. She has girls, I have boys. My two youngest grandchildren is 11, is 12, and 16, or 15 or 16. So there's nobody at my house that could play with her daughter. But in the beginning, when I moved there, she needed somebody to keep an eye on her kids or while she go do whatever. I let her, the kids come over because, I was like that. So I'd have my granddaughter, she's 15, 14. She, to sit in with the kids, play with them, whatever. And that's what she do. The part about Xavier choking the little girl picked up, Xavier was playing basketball. I'm sure you've seen the statements. I had them write it down. He was playing basketball. And then when he was going to come in the house, the little girl, she picked up his phone. And he said, give me back my phone. She said, no, and she started running. So my other granddaughter, the 15-year-old, she said, stop and give him back his phone. So Xavier, all of a sudden, he takes off to get his phone. Now, mind you, I wasn't there. I wasn't there when she choked her out. I wasn't there when she claimed her package got stolen. Because when she asked me, I told her I wasn't here, but I'll check it out. Just like that. So, and I talked to everybody and they said no. They didn't see her packages. So I was just like, okay. I told her I didn't know no information that I got from it. So if she had a camera watching everything, then she would know who took her stuff. Okay, just because we stay next door and we're Black, you want to blame it on us? I'm the only Black one in that little apartment, the fourplex. The thing about, there's one letter in there about my granddaughter said that, her and her other friend were playing, and her daughter wants to play with them, and they said no because they were, girls doing their own thing, and she started hitting him and being abusive to them, or however she was aggressive with them. So the kids said they were going to tell her mom. And so the little girl started crying. She didn't want nobody to tell her mom because I don't know. So then my grandkids, they just came in the house, so and it wasn't just one time, it was twice, 3 times, whenever they go out, and the little girl wants to play, but my grandkids is too old. They're doing other things other than what the little girl wants to do. Okay. When I was coming home, no, I was already home, and I was moving package boxes out of my apartment into a storage just to get some room. The little girl, she rides her bike, and her daughter, and she stops at the end of the driveway, and she's like, why are you moving? And I was like, well, that's none of your business. Just like that. I left it at that. This was after I was served and everything. And so the little girl, she just still stood there and watching, like she was told to watch or something. I don't know. I have a friend named Rhonda. She's here, and her son, and they come over my house all the time. And my dog isn't aggressive. He doesn't jump on them or anything, so why would he just be with them? I figure because dogs are keen. They have a keen sense and feeling, what I'm saying? And they can feel if somebody's trying to hurt who they protect. They're just not, my dog is just not out just to jump on people, just to bite people. She's not like that, I show it in video 2 and 3, 2 different times. I've been harassed that she's called CPS, adult CPS, saying that my daughter was pointing a gun at me and abusing me or whatever. She does that. Couldn't be nobody but her because I got all this stuff. And then the other time, the lady, she's knocking on my door, and she's like screaming, Marquita, Marquita. I'm coming from my room and I say, excuse me, why are you hollering? I'm visual impaired, not hearing impaired. You know, so she asks me a bunch of questions. Is everything okay? You know, about me and my daughter. I'm like, yeah, you know, where did you get that from? She's not doing anything to me, just like that. So then she just talks about, you know, if it's happening, let us know. You know, I'm saying, I'm sure I would if I was being harmed. You know, then another incident was, of course, you have it on the video. The people, they were knocking at her door, but then they turn around, the lady turned around, she looks at my door and she's like, points at my door, oh, like that, and says something. I'm not sure. She points at my door and then she turns back around and wait for her to open up the door. Now I don't know if they was calling on me, but that's what it seemed like to me when I viewed it from the camera. Okay, and yeah, it would have to be her because all of this came up. I don't mess with nobody. I mind my own business. I come and go, you know, as I want to. It's my house. I don't wonder about her. I don't pay attention to her, you know. About all this harassing and all that. I think she really is delusional and has this in her mind because I'm not even worried about her at all. I'm 60 years old. I have a disability. I'm trying to live my life and raise my grandkid. That's my grandson, you know, and all she wants to do, she wants to control what's going on in that house. She told me when I first moved there, there was another neighbor that was there before me that she didn't like, that he was on drugs and all that. Okay, I'm not on methamphetamine. I'm not on hard drugs. I smoke some weed, but I'm not on methamphetamine. Okay, so that's what she told me about the last neighbor that lived in the same apartment. Okay, now I think she's trying to I think she's working with the manager for them to kick me out so me and my grandson can be homeless. What for? I don't know. I think all these allegations she's made is not true. It's under perjury, you know? So basically, if somebody's going to say something about you, they should find out if it's true. You know, if it's exact true, if what they're going to say is true. If I really had a gun, you seen it, I really had a gun. And just whatever that they're going to say, they have to have evidence to back it up with. Okay. I would like to have her not bother me no more with all these allegations and run into the landlord about stuff. You know, the camera incident, I had placed it on my door. I thought everybody, that's when they got the cameras, they placed it on them at their door, you know, but the landlord said, put it on the wall right there. So every time I put it on the wall, it will fall down. So I put it up on top of the wall. Okay. When I view my camera, every time I view my camera, I see this lady, Miss Anicia, come out and she's stalking, looking right at my camera. She coming from her car, wherever she's looking right at my camera. Everything is she looking at my camera. Like, I'm like, why she keep looking at the camera, stalking me through the camera? You know, I don't know what the situation is, but that's what I would like. And it's all false allegations.
And Ms. Banks had indicated that on, I think, a number of occasions, she believes that you have blocked her car in.
No, when my daughter come in to drop my grandkids off or come in to pick me up, she pulls in and then waits for me or my grandkids, and then she pulls out. When I have to move myself in the apartment, whether if it's in the beginning or in the end or in the middle, I have to park in the middle right there. But every time I get ready to come or go or anything, my daughter comes and parks right there to let off somebody or pick it up. She's always ready to go. She's ready to go. She's always coming out of her house, flying out of her house. She's ready to go. She's ready to go. And it's not like we won't move, but it's like she's harassing me or trying to pick at me just by having to go every time I come in, you know. I see other people come in and she doesn't have that response to them, just me.
So is there a different place that cars could be pulling up?
No, I have
apart from right behind Ms. Banks' car?
I have two parking spots, which my car and my daughter's car is in my two parking spots. So when she come in, she just pulls in, or I pull in and I get out, go and do what I gotta do and come out and then leave. There's no other visitors if on the, and maybe on the street, but not in our little parking lot. It's two parking stalls to every person, and everybody has two.
Okay. All right, thank you. Ms. Banks, anything else you want to add?
Yes. So with the package incident, I asked Marquita if she had seen my package. I was knocking on her door for, I want to say maybe 30 minutes. Her grandson came home. I said, "Is your grandma home?" He said, "Yes." He went inside, got her. I asked her, "Did you by chance accidentally grab my package?" She said, "No, I didn't see any packages out here." I said, "Okay." And I'm like, "Is there any chance that your daughter could?" Because I have already seen the ring camera footage from upstairs, which indicates who have been coming and going from underneath the stairwell. And there's only two apartments. The only people that have came from underneath that stairwell was her daughter Amber, her granddaughter. I don't know her name, but she comes around often, and the little kids, Xavier and her little granddaughters. Those were the only people that have came from underneath the stairwell in that moment. And so I told her, I said, "Do you think Amber may have accidentally taken it?" And she said, "Well, she'll be honest with me if she did." So Amber got home. I got to Amber before Miss O'Neill got to her. And I asked her, I said, "Hey, did you take my package?" And she said, "No, my mom grabbed a package off the porch." And I said, "Interesting, because your mom told me that there was no package on the porch." So it's like, I mean, they didn't say that they grabbed my package, but Miss O'Neill lied to me saying that there was no packages on the porch, and then all of a sudden her daughter slips up and says, "No, she grabbed the package off the porch," and said that it was Amber's package. So that obviously it's a matter of elimination. Like, obviously you guys took the package. At the time, I do admit I didn't have a camera, and that is because and that's because of that charges were not filed, because I didn't have video evidence of them picking up the package. But I knew, they knew, as well as the police knew that they had taken the package. Miss O'Neill was also reluctant to give her granddaughter's name, her birthday, and all that stuff when the police officer was investigating the matter of the situation. So that whole me making that up is ridiculous. I wouldn't say that you stole a package or that I didn't know who stole the package. I wouldn't say that you stole the package if I genuinely didn't know, because I actually was on good terms with her at that moment. I would also like to add to the fact that me and her never had an agreement of her watching my children. I don't know where that came from. She watched my daughter one time when I went to go see my husband, and that is it. I don't know why she's saying that we had an agreement and that's why I don't talk to her. I literally, I'm a full-time mom. I have my kids all the time. Her not watching my kids did not affect my life in the slightest. In terms of the situation outside where Kaylani was choked, Kaylani did pick up a phone. However, she picked that phone up because they were playing basketball and she didn't want the phone to get crushed. So she picked it up. Xavier grabbed her and said, "Give me my phone," and started being violent with her. And the two little teenagers that I don't know their names, but her two teenage nieces are the ones that had to yank him off of her. And I had spoke to two witnesses, children, mind you, because there was only children outside, two children that seen the situation, and they told me word for word what happened. The same thing that my daughter told me. I am never going to say that my daughter's a saint in a situation or anything like that, in a situation where she was clearly provoking the matter, but also a little boy who is 9, 10 years old should not think that the solution to getting his phone back from somebody is choking them out. That doesn't make sense. I could see him maybe grabbing her and yanking the phone out of her hands, but to go behind her, grab her, to take her off her feet and restrict her airflow to where her legs are weak and she feels like her head is going to explode. These are words that came out of my daughter's mouth. That is not, no, I'm not okay with that. And there have been multiple situations with her dog attacking other neighbors. There have been multiple people that they have had issues with, that they have almost gotten in physical altercations with, because they have let their dog out off the leash and it has tried, because it is dog aggressive and it is like human aggressive. It will try to attack anybody. It's not just me and my kids. However, I'm advocating for me and my kids because I live right across from her. And I get to the point to where I feel like I can't even leave my house because that dog has tried to bum rush through my door several times. Also, I never, I wrote down my responses because I really wanted to be hyper vigilant about what she said. And, and I want to give this clarity to the courts and obviously to her. I never contacted adult CPS. I didn't even know that that was a thing. I never contacted adult CPS about any sort of matter that I don't even know what that's about. And our apartment complex and everybody in our apartment complex, and I can go take pictures right now and I can submit it to the courts. None of us have cameras on our doors. We all have them at angles showing the entrances in which people are coming up to their doors. Nobody has them directly across from their door. She had it on her wall, on the wall facing the entrance like it was supposed to be for months, and then randomly she got a new door camera and then put it on her door, and then she took it down and then she put it above the door because she had two cameras, and I have evidence of that I can submit as well, where she has the camera facing the wall to the entrance, and then she has another camera facing my house on top of the frame of the door. I am not delusional. I don't know why. I mean, for someone to not have much of a defense, because I'm being told that I'm harassing her, but every single complaint I've ever made has had evidence behind it. These have not been these delusional thoughts where I'm in active psychosis, or I'm having a mental psychotic break and I'm just imagining these things and I'm stretching the truth. My landlord has multiple instances where he has pictures, where he has text messages to support what I have to say. So I really, that's really discouraging to hear that that's somebody's defense when I have literal pictures of everything. And also with the whole gun situation, with me being harassed all these months, why would I assume that the gun that you happen to be pointing towards my house is a BB gun? That is not where my mind is going when Miss O'Neill and her guests have tampered with my car. They've had their dogs out knowing that they were human and dog aggressive. They have seen their dog try to attack my daughter. They've sat there and laughed about it and thought it was funny. And then, once it was going too far, Layla, come on, Layla, that's enough. Like, it's not okay, and it's not funny, and it's not acceptable. And they need to be held accountable. That's all I have to say.
All right, so you had mentioned in your petition, you believe they intentionally were blocking your car, and I've heard from Ms. O'Neill about that. You tell me about that.
Yes, Your Honor. So I have taken pictures and you have them, I believe. I'm not sure if you've seen them, but they have parked in the middle of the parking lot when they have multiple spots. So we don't just have two parking spots, Your Honor. We have what's it called? Reserve spots, and then we have guest spots. And guest spots are all for everybody. It's first come, first serve. They're not assigned to apartments. So there has been, I'm going to be honest, 99% of the time, there has always been a parking spot open in which they could have parked their third car, but they chose to park it in the middle. After I started to complaining to management about it, because I used to DoorDash quite frequently, and when I had to leave, I would have to sit there for 10, 15 minutes, honk my horn, because I just I don't want to be confrontational. I don't want to get involved in any sort of conflict that could turn into something where I get hurt, because I don't know, like, they're unpredictable. Ever since I started contacting management about this situation, they continue to do it more and they continue to do it longer. And I also have evidence of that. I have evidence of me contacting my manager, my property manager, and timestamps with it stating they're still there. It's been 3 hours, it's been 4 hours, they're still there. Like, I'm not making any of this up.
So when was the last time you heard from Ms. O'Neill?
I
Had
have
any direct
I have
contact?
verbally talked to her. I believe there was one incident where my daughter was walking out of the house with a uh a litter, like, we had cleaned the litter boxes and we were taking the litter to the dumpster, and Kaylani, she put it on her bike because she wanted to get there faster, and she was like wobbling a little bit, and she had like smirked or something and said, "Oh, she's got it." Like, that's the last interaction I've ever had with her. And then before that, I hadn't talked to her since February, when after my package got stolen, she contacted me and said, "Oh, nice to see you got a camera." Like, and it's like, I would have a camera after my package being stolen. Like, it was a very smart, sarcastic remark.
And has the Ms. O'Neill with the pistol, has that happened more than one time? Ms. Banks?
I thought you said Miss O'Neill. Sorry. So
Asking you, Ms. O'Neill with a pistol, has that
oh,
happened more than once?
so that happened recently after I was on the phone with a friend, and I said that I was concerned that they would retaliate and and I used it as an example, like, oh, what if they shoot up my house? And then I, like, literally right after I had told my friend that, she did that. So it hadn't happened prior to that, but it just seemed a little coincidental that it happened. And then the 2 days later, the toy gun situation happened.
And you have Ms. O'Neill said it was a BB gun, not something that fires live rounds. Do you have any information one way or another on that?
No, Your Honor, I don't know if it was a real gun or not. I just know it looks like a real gun. It looks like a real gun to me.
Okay. And you said, based on your camera angle, it was pointed at your house.
Yes, Your Honor.
All right, Ms. O'Neill, anything further?
Yes, I have submitted video where they're harassing my dog, making my dog always bark, because every time they get close to the door, if they're bad people or doing something, my dog's gonna react, because all dogs are keen, I have that keen sense, you know what I'm saying? So, and it shows that they walk close to my door, other than going down the ramp from their side. They walk close to my door and then turn in front of my door, trying to make my dog bark. Now, she was with them, so she knows about them, whatever. Or told them to do it. I don't. That's what it seems like to me, So about the other gun that my daughter had, that's a BB gun too.
And Ms. Banks, did law enforcement, when they reviewed the video, did they say that looks like a BB gun, not a live fire weapon, Ms. Banks?
So, Your Honor, they did the second gun was visibly a toy gun. With the first one, they never disclosed to me that it looked like a BB gun. They said that they were going to open and investigate it. That was all that they told me.
Nobody ever came to me, no law enforcement came to me and said anything about the gun.
And Ms. O'Neill, do you have a weapon other than a BB gun in the home?
No, sir. All I know is that I can't have one,
You've been restricted.
Excuse me?
The court has restricted?
Yes, I've been a felony, so I would have to, a felon, so I would have to get pardoned by the state, and it takes so I wouldn't, not raising my grandkids.
And Ms. O'Neill, can you tell folks who are coming to your place not to, you know what Ms. Banks' car looks like, correct?
Yes, I know what her car looks like.
And will you tell people not coming to your place to not park behind her or in a way that prevents her from departing?
Yes. And I have, yes.
And do they continue to park behind her? She says that's a problem.
Don't nobody even come to my house and park right there but my daughter. And she's my care provider too, my caregiver.
She understands she can't park behind Ms. Banks' car.
Yes.
Ms. Banks has to have the ability to be able to leave the parking.
Yes. And she can leave when my daughter parks there, she can pull right out and go on just like that. She just wants us to move. She just has a problem with, she wants us to move. We don't pull like right behind her car to where she can't move at all. My daughter pulls close to my apartment to let me off or to wait for somebody. She has enough room to get out.
And Ms. Banks, is that accurate?
No, Your Honor, that is not accurate. Her daughter has a large SUV that I'm pretty sure is a third row potentially, and the distance between the parking spaces on my end and their parking spaces on their end, there's not enough room. And I have a compact car. There's not enough room for me to back up and drive out. I would have never said nothing to them if that was the case.
It's a small SUV. It's not a big SUV. It's a small one.
Okay, thank you.
May I say one more thing?
Sure.
When she talks about I was prancing in front of her window or whatever with the gun, animosity or whatever, that never happened, Judge.
All right. Ms. Banks did say she had law enforcement come out and review the footage.
They never came to my door.
Okay. They didn't speak to you, but you don't know that they didn't.
Yeah,
You
I
know
didn't,
anything about them seeing the footage?
that they came to her house
Ms. Banks, so
to see the footage.
right.
I'm sure if I was doing all that, then they would have came and said something to me. If they felt it was intimidating, anything that I did, walking out, then they would have came and said something to me.
Okay.
Oh, excuse me, Judge. Another thing, if she was so afraid of me and my family, because that's just my family that comes over to my house, not no people, my family, then why would she sweep in front of the doors like she trying to help me, but sweep after my grandkids go in the house, and she sweeps closer to the store and bend over like she's listening, like trying to find out what's going on in my house.
Your
That's
Honor, if
what
I
it
could
is.
respond to that,
Okay,
please.
Ms. Banks, you don't need to interrupt.
I'm sorry.
So that's what it appeared to you. You don't know that's what she was doing, but that's
Right.
what it appears to you.
Right.
Okay. All right. I've heard a lot. There's a lot about what I've heard that is what we call supposition. People believe something happened, but they don't have actual direct information that such a thing happened. They have intuition, they have a gut instinct that says this is what happened, but I can't really act on that. So the allegations that the cars are intentionally blocking Ms. Bangs, I hear what she's saying, but the intent of the party to do that, I can't tell. It's just a guess. Who took the package? There's no direct evidence as to who took it. Ms. Banks certainly believes that it's Ms. O'Neill or somebody in her family who took it, but she doesn't have direct evidence that that's the case. And we don't restrain people based on the actions of their children. So that's also an issue that we can't deal with. And we don't restrain anybody from making calls to law enforcement, to landlords. People are free to make those calls, to child protective services, to adult protective services, whatever it is. People are free to make those calls, and it's up to those agencies to decide whether they are going to treat those calls seriously or not. So the fact that somebody may be calling those agencies is not a basis for the court to enter an order in any case. In this case, the most specific concern I have is the allegation that a firearm was pointed at Ms. Bangs' residence based on the camera footage, and Ms. Bangs asserts that it's pointed directly at her door and then down her wall. The nature of the firearm being a BB gun or an actual firearm, Ms. Bangs seemingly honestly testifies that she doesn't know whether it was. Ms. O'Neill told me it was a BB gun. It may very well have been a BB gun. But the nature of doing that, I think, is warrants issuing an order, and I will do so. Ms. O'Neill, I'm going to issue an order telling you may not have any contact with Ms. Bangs or any member of her family. And Ms. Bangs, this order will be in effect for 1 year from today's date. If you want it renewed, you'll have to come back to court and ask for it to be renewed. Given the fact that you're immediate neighbors, I don't impose any distance restriction in this case, and I can't impose any orders on other adults living in that home. The only person who is before the court today is Ms. O'Neill. So Mrs. O'Neill is directed not to have any contact with Ms. Bangs or her two children. All right, we'll give Ms. O'Neill a copy of this order, and Ms. Bangs, if you wish a copy of this order, you can obtain it from your file with district court.
Thank you, Your Honor.
All right, thank you. Ms. O'Neill, just sit tight and I'll get you a copy of that.
All right, we are back. We're going to address a zoning violation matter. We did have a personal protection order hearing at 10:30 that took us up till before the lunch hour. And this matter is the only thing we have scheduled for this afternoon. So the title of the matter, there are two files, 251466ON and 14670N, both versus people of Fabius Township versus Mary Ann McLean. Miss Mary Ann McLean is here. Gary McLean, who also resides on this property, is here by themselves. Attorney Eric Geschwind is here on behalf of the township. Before we address anything, I have received date stamped yesterday a stipulation to withdraw as counsel from Nicholas Spiegel from Christ, Enderley, Hudgens, and Borsos, who had been representing the McLeans. It's dated August 14th by the McLeans and the 13th. Ms. McLean, at this point, you wish to no longer have the services of Mr. Spiegel, is that correct?
Well, he quit. I didn't ask him to, but I can proceed.
All right. Ms. Geschwind, do you have any opinion regarding that or any objection to Mr. Spiegel's withdrawal?
John, I did file a written motion. The long and short of that is I have no objection based on the allegations made by Mr. Spiegel.
I didn't see your motion.
Let me see what date it was filed.
Can the volume be turned up at all?
What's that?
Can the volume be turned up at all?
Well, they did turn it up. Maybe it's me you can't hear. We've got some hearing aids, some headphones if you wish to use those.
Please,
Could you
yes.
get a set for Mr. McLean? I'll try to speak up.
Your Honor, it was sent on August 11th. I can email the court a copy right now.
Yes, I don't know where it is.
All right. Who would you like me to send it to? It's my understanding Tab is not there today.
Yeah, that may be the problem. These things may be set aside somewhere, waiting to get filed in the file. For that, I apologize. And if Mr. Spiegel filed something other than this, I don't think I see that either.
I can
Mr.
send
McLean
you a
was
copy
in
of. I can send you a copy of what he filed.
Yes, please. I shouldn't have to get it from you, but I'm not finding it in the file.
Okay.
You brought my copy. I didn't think of that.
Okay. You should have both in your inbox shortly.
Well, I apologize. I haven't read these. And I didn't see Mr. Spiegel's motion to withdraw. All I got was a stipulation to withdraw. That's not good. So essentially, you're acknowledging you don't object to the withdrawal. So thank you for that. That's dated August 5th. It doesn't. Maybe he sent it to you, but never filed it with the court in light of the fact that there was a stipulation. Anyway, at this point, reluctantly, I'm going to grant the motion for him to withdraw his counsel. Ms. McLean did a more than adequate job of representing herself through most of these proceedings. I kept telling her I thought she could benefit from counsel, and apparently it didn't work out. So maybe it wasn't the best advice. Here's Mr. Spiegel now. He isn't actually withdrawn until I sign the order, which I just did. So in hindsight, we started early. We should have waited till 1:30, the appointed time. Mr. Spiegel, would you join us, please?
Yeah, you just said it, Your Honor. Until the order was signed, that's why I'm here.
All right, I've signed it, but did you actually file the motion to withdraw or simply file the stipulation and order?
We filed the motion, Your Honor, and subsequently, Ms. McLean did execute that stipulation. I believe we did.
Well, it's dated August 5th. It never made it to the court. So that's troubling. That's an institutional problem. People have been on vacation. But all right. At this point, then, I did appreciate the help. I was hopeful we could get this to the finish line. In fact, I wish this whole case would just go away and be done. Maybe everybody feels the same way. It's like Chinese water torture. At any rate, Mr. Spiegel, I will allow you to withdraw. I apologize. I didn't see your motion. I'll deal with that internally. But she agrees. She said she can represent herself. Opposing counsel does not object. No need to go into all the reasons. Let's just say there was a breakdown in communication. All right, you're excused. You may vacate. You can certainly watch the proceedings if you wish, but you're good to go.
Thank you, Your Honor. I appreciate that.
This matter is a 2005 matter. It's now August of 2025. And we've been kicking this can down the road for months. Our last hearing was March. A number of things were going to try to be accomplished. I was very hopeful. We went from March to May. Last hearing was in May. That a number of things would be accomplished. I wrote in here, continue to Wednesday, August 19th. If passes inspection before that time, Spiegel would share that information with the township and the case could be dismissed. Continue the matter to today and allowed Zoom. And here we are. So, Ms. Geschwint, what's the posture of the matter?
At this time, I have received no notifications that inspections have even happened, let alone that they've been passed due to the reasons mentioned in Attorney Spiegel's motion to withdraw. It certainly seems that there's been a breakdown in the communication. There could be something that the McLeans have that I do not know about, but I have not heard of any inspections occurring, let alone being passed.
In his motion, which I just got, we discussed this case in March. We discussed it in May. Paragraph 3, Mr. Spiegel states, from the firm's position, there's been a breakdown of the attorney-client relationship related to the defendant's refusal to engage in agreed upon inspections and maintain consistency in representations made to the court. And then he goes on to say there have been other issues. But one of the issues, the first one he cites, is the failure to complete the inspections. I was hopeful they would be done, the case would be dismissed, and Ms. McLean, what's your position regarding what's set for today?
Well, breakdown of communication has been on Mr. Spiegel's end.
Well, all right, so he's out.
Right, but
Have the inspections been done?
oh, absolutely. Absolutely. My license has been in placard on the farm since June. So
Your Honor, could I have a moment, please?
Yes,
You want me to get up there or this fine?
you're fine from there.
Your Honor, you know that my wife and I share the property, the total responsibilities of that, no matter what. I haven't been involved. My name hasn't been mentioned on anything. I know you're aware of that. And I appreciate that. And I also apologize for this whole mess with the attorney. We have had a breakdown in communication. There's been several times when we've asked him to do different things, of which he was late showing up different times for the meetings. He would take my wife off to the side right before a meeting when we walked in. He come into the meeting late because of it. There's other problems too, but that all will be taken care of. That's our responsibility to handle. We will do that. But one thing that bothers me about this whole thing, we started all this with the ordinance problems. The Fabius Township ordinance permits farm housing still today. I got the article right here if you'd like to see it or if you want me to read it, whatever.
No, I'm aware of it.
Okay. So I don't know why that is such a problem that we were kind of forced into doing the migrant camp thing. There's been several accusations by Mr. Kuhlman at different times, and that was one of them when he was here on witness stand, and he was quoting ordinances from R3 residential about all this, and we are zoned agricultural R1. So this is the ordinance that we were following at that time. And then he sat there and on the stand, and he said that he wasn't the one that put that placard on our door. I have a copy right here that's still on my door, dated and signed by Mr. Kuhlman. Mr. Kuhlman seems to abuse his authority, his shenanigans of whatever he's come up with, even with you, Your Honor. You told us during this hearing one time that he did not get authority to put that on from you, and you were the only one that could authorize that. And some of these
Well, that
things,
wasn't exactly the correct quote, but they only get their authority from me. The zoning enforcement or many other things. They cite somebody, and just like in a criminal case, there's a presumption, and they have to overcome the presumption for the finding. So yeah, they can say, well, you got to do this. It isn't binding until the judge says you got to do it. So I made a sort of a statement on the record about it in the context of this case, but
yes,
yeah.
yes. So anyways, there's the proof. The man did put that. He tried to say that, what was his name?
Randy Schmeling.
Randy Schmeling put that on the door. It was him. He did it. It's just some of his shenanigans that he is trying to enforce. He's taking advantage of the township. He's taking advantage of us. He's taking advantage of the court systems, and all this dragged out because of all these things when he didn't even quote the right ordinances on. I
Well,
apologize.
he is retired. He's no
I know he's
longer
retired. He's
he's
still
serving
taking
as-
advantage of the township by, like this. He
Well-
says that he didn't do all these things, but he did. He's even using the wrong ordinances to try and make this hold up in court.
Well, let's see if we can get somewhere. Ms. Keshwent, well, first of all,
One more
Ms.
thing,
McLean,
John.
you say you've got the inspections that are at issue. What
We
did you
have
do
the
with them?
license.
Did you ever give them to Mr. Spiegel?
Yeah,
He's been notified, yes.
The last 2 times in court said he didn't have this and didn't have that. Handed them to him myself. So I don't know what he does with them. Those have to be hung in visibility.
You ordered the township to get an inspection on the property, and then that didn't even work.
All right, I have in front of me, Ms. Geschwent, an agricultural labor camp license for Critter Creek Farm, effective June 23rd, 2026. One house, family or single gender owner occupancy 8. It's from the Services Division of the Migrant Labor Housing Program. At one point, the township had said if they can get the migrant housing, we could close the case. This does appear. Have you ever seen this?
I have not, Your Honor.
Would you ask Jen if she could scan this in, and my secretary left on a family emergency. I'd have a clerk in here and email it to me.
Took a little longer than anticipated. We ran into.
Well, you were in here a time or two earlier in the week. Why didn't you file that then?
I thought Mr. Spiegel might.
Oh, well, you're right. At that point, you were still represented by an attorney. Good point. Up until 5 minutes ago, you were still represented by an attorney. So you're saying you did provide it to him?
Yes.
Yes, ask Lapita if she would scan it and email it to me, and I'll email it to Aaron. And make a couple. Is that my copy?
You can have those. I got more.
All right. Yeah, have her scan it so I can email it to Aaron. So the inspections that we discussed, were some state inspections. Some had been done, the electrical, well water, I think some of those were done. And then if passes inspection, maybe dismissed. Do you have any other reports that you gave to Mr. Spiegel that you'd like to give to the court?
He didn't want copies of the actual people who inspected.
Well,
The
do you
state
have-
doesn't come down and do the
Well, do
inspection.
you have any inspection reports?
Not with me. I can tell you who did the inspections.
Well, not with you, is not your style. You usually got everything.
I know.
Fingertips.
Sorry, I wasn't sure.
All right, yeah, who did the inspection?
Harrison Electric out of Fabius Township did the electrical. And we passed with flying colors, even though it was done forever ago. We're above code on that. Cool Breeze Mechanical, Sean Bortnick out of Three Rivers, who had installed the air conditioning and the heating system just a couple of years ago, looked at it and said, yep, that's my work. It's still up to code. It's working. So
Did you provide that information to the Department of Agriculture?
Oh,
The
yes.
people that gave you the migrant housing.
Yes,
So-
absolutely.
So you gave that information to
To
them?
the state, yes. To get the license, it had to all be done.
All right. When did Harmon Electric do the inspection?
The what?
Harrison Electric. We were here in May. Was the inspection after May?
Mhm.
I think so, yes.
Well,
About a
they
week.
requested it.
And
only thing
Cool
that held us
Breeze
up was
was
the water
after
test.
May.
We had a little trouble with the witches. Oh, some good always comes out of everything. It turned out our bladder had failed out because we have an in-ground 5-inch well and the bladder had failed. We didn't know it. It was causing some problems with the quality of the water. So
And it probably makes your,
electric got
Electric
higher.
run
But
all
how
the
do you
time.
know, right? They always get higher. But at any rate, it replaced the tank and did all the work on the well. Lewis well, C&D pump out of Three Rivers. Ryan Lewis did that, and it's all new and done, and we're back in business.
They also, the state sent an inspector to physically look at everything,
Yes,
inspect the rest.
say that the state inspector came out and physically looked at
Yes.
everything.
Mhm.
This thing doesn't have a name on it.
His name is
Um,
Andy. Know that by heart.
Do you have any other correspondence?
Andy Raymond at michigan.gov.
Andy Raymond?
Yes, he does all of the inspections. I was surprised to know there's like 28 migrant housing in Three Rivers in the city limits. I was surprised to learn that.
Oh, in order to do this, I have to spell Geschwind right.
Unfortunately, yes, you do. I think I spelled it correctly in my Zoom name.
Geschwindt. Thought you were in my library, but you're not. Has it arrived yet?
Yes, I'm looking at it right now.
All right, thank you.
If the court would permit, I guess I thought that we had agreed to potential building inspections as well as fire inspections were part of the underlying cause. I'm not sure that the state labor license, camp license inspects that, and I don't see any report of that being inspected. So if the court would permit me to have, say, even until a week from today to just verify with Mr. Raymond that those things were inspected and passed, I would appreciate that.
All right, yeah, this is a bit bare bones on its face. The defendant was not under oath, but I don't have any reason to doubt what she's said here. In fact, let's put it under oath. Ms. McLean, you swear to the best of your ability, any statements you made here will be true to the best of your knowledge and belief.
Yes, I do.
And everything you've said so far about the inspections that were done, the electrical, the mechanical inspection, and the agricultural labor camp inspection, those were true to the best of your knowledge and belief.
Absolutely. You can't get a license unless.
Yes, I know
Well,
from
that-
some of those 28 houses in Three Rivers are landlords that rent to migrant workers. And in order to rent a tenant to a migrant worker under this particular act, you have a pretty rigorous inspection.
Mhm.
And so I'm aware of it from my duties as the landlord tenant judge. Yes, Ms. Geschwint, at one point you had represented if they got this license, that would satisfy the township. I think Mr. Coleman was of that mind. It appears that she's got it, but you wish to verify further.
Yes, if the court would just give me, I mean, I'm happy to do it this afternoon.
Well, that's difficult to do. You don't know if he's there or what's there.
He usually
He's not.
answers right away. I can give her his email.
Well, all right,
I
what's
have it.
his email address? Oh,
I
she
have it.
has it. She works with him.
Oh, he does. See,
She's all over Southwest Michigan and township representation, so she's dealt with a lot of. All right,
The fire permit and all that, or the inspections were completed by that state man. That's part of the,
all right, fire inspections were also done.
yes.
Mhm.
And that's all that I need to verify because there's just not much on here. It's different from the other ones I've ever seen. So I just want to ensure that those things were done and completed. And then I'm
All
happy to follow up with
Yeah.
the court.
My only goal, as I said, I wish we could get this case over the finish line. I don't wish to leave anything for my successor. So we got to finish this by December 30th because being shown the door as of that date. And I don't want to leave something like this for my successor to have to deal with. We've got lots and lots and lots of hours invested into this. Let's see what we've got for available time.
Your Honor, that,
Yes.
that license has that number and everything attached to it that combines all those regulations.
Well, she wants to verify that, and I guess I'm gonna let her do it. I don't disbelieve you.
It's online. They got all the, what you have to complete.
Well, for one thing, I didn't see this, or neither did she until 5 minutes ago. So, Mr. Spiegel didn't file it. You didn't file it because you were still represented by an attorney. So,
I apologize.
I understand. So in defense of her, she wants to take a look at it. Now, I often use Wednesday afternoons, odd numbered Wednesdays for these type of zoning hearings and other matters, but they're filled. I've got a mobile home case that I've been trying for weeks. And I've got juries on, let me see, I have on the 2nd of September. I don't have a jury on September 2nd.
Unrelated.
How about if we go 2 more weeks? Maybe we can put this case to rest. September 2nd at 1:30.
Can't do that.
That doesn't work for you?
He has a brand new shoulder put in next week, and that's the date of his appointment in Ann Arbor to see the
Okay.
doctor after. Those are hard appointments to get.
Do we need to be available if it's just about this?
Yeah, I'd like to. I got another ugly landlord tenant trial. How about Wednesday? This is Fair Week. I'm not sure how that affects things. Wednesday, September 23rd at 10.
Yes, that works for me, Your
I
Honor.
have to do Zoom. My granddaughter will be in the show ring at St. Joe County Fair.
On Wednesday morning? Yeah, nothing's ever easy around here.
Can't disappoint her.
All right, how about Thursday, September 17th at 10.
Wide open.
Does that work for you, Ms. Geschwint?
Yes, Your Honor.
At what time was that?
10 a.m.
Perfect.
It's not a normal time for this, but we'll fit it in. Now, Ms. Geschwind, again, you're able to appear by Zoom. You guys are able to appear by Zoom, but you're also welcome to come live. Now, just as a caveat, they were supposed to try a jury trial in here today. Judge Ball had come over here from Three Rivers. We have 4 courts. We only have 2 functional courtrooms. And one of these is this one, which is not ideal for jurors. It doesn't have a 12-person jury box, doesn't have a bathroom for the jurors, but it was the courtroom. And so every other month, we're going to try a case over here. Visiting judge will try cases while Judge Stutzman is recovering. So today was supposed to be a jury trial. They had 70 jurors show up this morning. One defendant pled guilty and the other case got adjourned. So they sent all the jurors home and I got my courtroom back. Otherwise, we'd have been in that little bitty hearing room and all the spectators wouldn't have been able to come in. So they would have come over here. I don't see that problem for the 17th of September. I don't know what Judge Pattison has for that morning, but normally that's a time that I've got the whole courtroom.
We really prayed this would tie up today.
Now, in the meantime, Ms. Geschwind couldn't talk to you because you were represented by an attorney. She talked to Mr. Spiegel as recently as earlier today, but she couldn't talk to you. Now you're not represented by an attorney. So if she's satisfied with all this, it's a possibility this could be done without even having a hearing. My preference would be we put everything on the record in open court. But if you can work something out otherwise, that's all right. So we're going to continue this again. Continuances are the bane of our existence. But she wants to verify the representations you made. She has a working relationship with Andy Raymond from the state. She'll confirm it. Perhaps if it is reconciled, we can do some sort of a closing order, have it ready to execute on Thursday, September 17th at 10. At this point, I fully expect it will be in this large hearing room. If it is not, I'll try to let you know because you're my classmates and other people that are here won't be able to come in the room. It's about the size of a closet.
I wanted to see how 70 people fit in that hallway.
Well, they've tried to get them. There aren't 70 seats in here. I'm not sure how many jurors. They summoned 71. I'm not sure how many actually showed up. All right, Ms. Geschwind, you will do your due diligence. We will continue this to Thursday, September 17th at 10 a.m. Hopefully we can get the matter to closure at that time. And is there anything else you'd like to place on the record?
I have nothing further at this time. Thank you, Your Honor.
Ms. McLean?
On the 25th of September, Roxanne Sieber put this, or Gershwin, excuse me, put this on the record that I was found responsible for a violation of the zoning ordinance. Just because I've done the migrant license doesn't mean that I'll be exonerated about that. And Wordlemans are really fussy about their names. And do I have to appeal this decision?
You may have to appeal that one, unless they just end up dismissing it somehow.
Because that was on the nuclear.
Yeah, that was a finding that I made a year ago.
On the nuclear option thing here.
Yes. So let's see where we get with this. Anyway, thank you all for being here. You're welcome. It's a public courtroom. This is being live streamed. There's no secret about it. So we'll take a final crack, I hope, September 17th at 10 a.m. You're all good to go. Thank you.
Thank you, Your Honor.
Thank you. Thank you.
All right, we'll go on the record. Case is entitled State of Kansas versus Destiny Livingstone. Case number 23 CR 300035. Would counsel announce appearances, please?
May it please the court, this state appears by Gilgillette County Attorney. May it please the court, Ms. Livingstone appears via Zoom from the Greenwood County Jail. Counsel Christopher Ambrose of Harvest Legal appears via Zoom as well remotely.
All right, Tony Bauer appears and he prepared the PSI. Christy Ashenfelter from Community Corrections also appears. We're scheduled today for a sentencing hearing, which is kind of a long time coming. There was a plea back on March 27th of 2025. A no contest plea was entered to a possession of methamphetamine, paraphernalia, traffic registration offense. Miss Livingstone has been incarcerated in the Oklahoma Department of Corrections most of the time since then. There have been issues having her on here so we could get her sentenced. She's now back in the Greenwood County Jail. Mr. Ambrose, rather, are you ready to proceed to sentencing today?
Yes, Your Honor, and we do have a departure motion filed on this case.
I did see that. And Ms. Gillette, are you ready to proceed with sentencing?
Yes.
All right. Earlier stated, I did receive the PSI that indicates a criminal history score of B as in boy. Ms. Gillette, any objection to the criminal history score?
No.
And Mr. Ambrose?
No, Your Honor.
Ms. Livingstone, you're not objecting to the criminal history score of B? You're
Ms.
muted.
Livingstone, you're muted there.
You know how to unmute that?
No, sir.
Okay. All right. Ms. Gillette, are you aware of any legal reason why we should not proceed to sentencing today?
No, Your Honor.
And Mr. Ambrose, are you?
No, Your Honor.
All right. As Mr. Ambrose stated, he did file a motion for dispositional departure. I do have a copy of that and had an opportunity to review it. Mr. Ambrose, if you could provide your argument in support of your motion and your sentencing recommendations at this time.
Yes, Your Honor. We're going to be asking that the court depart and allow Ms. Livingstone the opportunity to be placed on probation in this case for the following reasons. First off, Ms. Livingstone, we do have a drug and alcohol evaluation completed for Ms. Livingstone. We've got that done through a new journey. They recommended that she engage in level 1.5 outpatient treatment services. If granted probation, the plan would be Ms. Livingstone would be living in Wichita. She would be able to get into services, those recommended services there in Wichita where she'll be residing. Sounds like the plan is, just so the court's aware, is if she was granted probation, she would be living with her sister to start out with there in Wichita. I think probably once she gets on her feet and gets back going, she would be moving out on her own, but that'll obviously depend upon how, with the treatment obligations, because we often know that when people are involved in treatment, sometimes maintaining full-time employment during that time is kind of a challenge. Additionally, Ms. Livingstone's young child would be living there with her. Fortunately, due to some very intelligent planning on her part, she was able to get a temporary guardianship set up with a family member. So there is no state involvement, no scene case involved with that. So Ms. Livingstone would also be taking care of her young child there at that residence. Would also note for the court, Ms. Livingstone does have a B criminal history. That's why we're having to ask for this departure. Those convictions arose out of the 2014 conviction. Those convictions arose out of the 2014 case and the Oklahoma case that she'd been in custody on, and in the Oklahoma Department of Corrections. Prior to this, she has no drug felonies. And I would also note for the court that if you look at her criminal record and just look at it at the number of entries on the sheet, there's a lot of them, and I'm not disputing that. However, most of those are traffic and driving offenses, which is unfortunate, but it is very common. That would also note for the court that along with that, while it's not something directly the court considers, Miss Livingstone has been in custody for quite a while, and I think she realizes that she doesn't want to be there. She wants to be able to take an opportunity to move forward in a positive direction, get to be with her family, start moving forward in that direction and get her life built back together. As the court had indicated, simply the fact that she was in custody in Oklahoma complicated things to get her to sentencing in this case. One of the primary issues we had outside of, we had some issues with Zoom availability and stuff like that, but beyond that, this is a bids case. Miss Livingstone, we needed to get a drug and alcohol evaluation for her. We weren't able to do that out of state because of the bids regs. We got to get those done with a Kansas provider. And so that's one of the reasons why we're here like that, just so the court's aware. Finally, by entering the plea in this case, Ms. Livingstone did save resources for the state as well as the court. We avoided a jury trial here. Ms. Livingstone is additionally going to ask to speak in a moment, I believe, so she can express her desires as well. But that's what we're going to be asking for, is that the court grant her the opportunity to take advantage of these take advantage of this plan and let her move forward in that direction, take advantage of treatment on the outside, so she can continue moving forward in a positive direction. I will note that, one thing that we're often concerned with is clean time. She has a significant amount of clean time at this point because she's been in custody for so long. Now, moving forward as to the sentencing recommendations, we're going to ask the court order the standard underlying sentence of 34 months on count number 2, possession. On count number 8, the paraphernalia charge, and I ask the court to issue an appropriate underlying sentence on that, and ask the court to run that concurrent with the count 2 being, since it's the main count there. Would note for the court that there's if probation is granted, be a 12-month probation duration, 12-month post-release supervision duration. Would note that she's not SB 123 eligible because of the criminal record. Furthermore, we do have 50 days of credit for time served in this case. And
I was going to ask you, based on the recent changes in the law, or does she possibly have any additional days of jail credit, or was that taken into consideration?
Those were out of state, Your Honor. I don't believe we have any case law supporting that at this point in time. And whether be it unfortunate or fortunate, I have argued, probably argued close to 20 urban cases now. And I think I've argued some in front of you. I've argued them all over central Kansas. The considerations in that statute appear to only apply to someone is in Kansas custody. And so unfortunately, I don't believe that's going to apply here. Beyond that, just for total candor purposes, as of July 1st, HB 2444 attempts to close down any further urban arguments. I'm not litigating that today. I think there's constitutional issues with that statute. However, that's the position of the law as it currently stands. So at this point, based upon where we're at with the interpretation of that duplicative credit issue, I believe that the only appropriate time here is going to be the time that it is reflected in the PSI.
What's the status of her Oklahoma? Is she on parole, or has she maxed out her time on what she was doing there?
She flattened her time. She flattened her time out in Oklahoma, so she's done with them.
Okay. And she's only being held in custody now on this case?
Yes, Your Honor.
Okay. All right, Ms. Gillette, your response to departure request and recommendation?
Your Honor, her bond conditions were to, not specifically, was literally listed, not just in the printed ones, but actually written in. She was to refrain from violating any laws in the United States or state laws, or city ordinances. And then it specifically says no contact with Adrian Sledge, who was her co-defendant, no unlawful acts, no possession of any unlawful substances. And so her plea offer was also to plead to counts 2, 8, and 11, dismiss the rest, and she'll need to behave, no new cases. She went out and got a new case. She ended up spending a lot of time in Oklahoma prison over a new case. So, you know, she made the choice to go out and get in trouble again. Not one, but she's had 2 cases down there that resulted in her issues in Oklahoma and going to prison in Oklahoma. She ended up getting a new case that delayed her time here significantly. We got a drug and alcohol evaluation after she got back here to Kansas. She's been in custody, and she has some significant jail credit here as well because of the time that she has been here in our custody waiting for this sentencing. We had wrapped up to the point of sentencing when this all occurred. Because of getting the new case, you know, when individuals cooperate with the court, they cooperate with the state, they go into treatment willingly right out of custody. A lot of promises were made by Miss Livingstone when she was asking for a bond about staying out of trouble and cooperating in doing treatment and wanting to do things, and then goes out and gets new cases. That doesn't make me have to recommend very good recommendations. So I'm going to object to the departure motion because of all the stuff that she has done.
Okay, so what are your recommendations?
My recommendations is going to be, because she has spent so much time in custody, mitigated. My recommendation will be to, her mitigated number would be 32. So my recommendation is going to be 16 months. I guess I would recommend a durational departure to 16 months with up to 20% good time credit. That would cut her mitigated time in half. I'm not going to recommend a dispositional departure. And post-release would be 12 months. And she's not eligible for Senate bill due to her criminal history and living out of state. On count 8, the possession with intent to use paraphernalia, it's a class B, and recommend 6 months concurrent. And on count 11, it is a unclassified misdemeanor. I'll recommend 30 days concurrent. Court cost, there's a KBI lab in this case, booking and fingerprint fee. And I was looking to see if she had, I believe her DNA is already on file from, she had a Sedgwick County and Saline County cases. So I don't know if her Kansas DNA is on file. I believe it is due to a Sedgwick County case from 2016. So I believe her DNA is already on file, and we wouldn't need an additional cost for DNA. And she has jail credit of 50 days for Kansas.
All right, anything further?
That's it from the state.
All right, Mr. Ambrose, any additional recommendations, response?
Judge, I think we'll stand on our earlier argument. I know that Ms. Livingstone will want an opportunity to address the board as well.
All right. Ms. Livingstone, I'll give you an opportunity to address the court if you wish. And you're muted.
All right, I'm Destiny Livingstone. I didn't intentionally go out of state and try to get new cases. I simply was on my way to Texas to a will reading, sir. At that time, my baby daddy of my youngest did some things, and they charged me with it too. I'm not stating the fact I did my time. It's over with. I never missed a court date here besides the time I was incarcerated in Oklahoma. I got in touch with you guys the day before, like a month before I was supposed to go to court, and they issued a warrant out for my arrest. I had my sister call up here and let them know that I was incarcerated in Oklahoma. I never dodged you guys. I've always tried to make my court dates. I'm from Kansas. I was coming back. I've never lived out of state. I've always lived in Kansas. And I just hope that you see that I have corrected myself. While I was in Oklahoma, I got my forklift license. I can do anything in a warehouse. I got all the certifications for that. I even took parenting classes while I was there. And I'm just ready to have the opportunity to show not only you guys, but my kids that, hey, it's over with. I'm 41. I'm done. Like, I can't do no more time. That's all, sir.
Do you realize had you not made that trip to Texas, you would have been sentenced with maybe a Senate Bill 123, probably a year or two ago?
Yes, sir. I do.
So what if you were given the opportunity to be released, tell me what you're going to do.
I'm going to get into classes like I'm supposed to. I'm going to find me a job and just take care of my kids, sir. I don't even have the desire to even do any more drugs. I've been rehabilitated. You know, I don't have the desire. I don't have the want. I just want to live right now. You know what I mean?
It's a lot different when you're out of custody and trying to stay clean.
Well, I've been clean for almost 3 years, sir.
You've been in jail or prison for 3 years, right?
Yes, sir. There's drugs there, sir.
I understand. That's what
I have not indulged in any of those activities. I'm ready to change. I was ready to change then. I will even give up a hair follicle to let you know that I haven't even indulged in prison.
And you've maxed out your Oklahoma cases?
Yes, sir.
Your Honor.
Yes.
I never got any records back after sending a request. However, the Oklahoma court website does show she is on a deferred adjudication. In a child neglect case, it is not in her criminal history because it's in deferred adjudication. But she is on that. It shows she is on that until September 2028. And I don't know what her requirements for that particular thing is, but she is on that. Yeah, according to their website.
That's just to stay out of trouble. They just don't want me to get in no more trouble. And they also knew I had this case. I can't catch any more cases or anything.
So technically, she hasn't flattened her time if they still have the ability to bring her back if she does get in trouble.
Her cases that she was in DOC for, that has been completed, flattened. I thought maybe she was on parole, but I can't find anything to indicate she is. And she's saying no. So I would go with that. But this is a separate case. This is an older case. It's a 2014. Give me just a second, Your Honor. It is a 2020 case on a child neglect, felony child neglect 2020 case that they had a warrant out when they picked her up on her new case down there. Then they resolved this case as well with a deferred adjudication on it.
Yes, and I showed them all the paperwork that I've done, all the classes, all the tests to get my kids back. You can check the Wichita records. I've completed that way before time. The only thing that I didn't do was send that to them because I didn't know that I was supposed to send that to them. I thought the DCF was going to send that to them. And so they gave me a deferred 3 years to not get in trouble. And that's it.
All right. For the primary offense of possession of methamphetamine, a level 5 drug felony, with your criminal history score of B, I've considered the request for departure, and frankly, I'm torn here, Miss Livingstone. Had this case progressed as it should have, you would have been sentenced long ago. You would not have been presumptive prison. You would have been on probation, maybe completed it by now.
Yes, sir.
But that didn't happen. You went down to Oklahoma, and I don't know what happened there, but you picked up some very serious charges that now have you in a presumptive prison category. I can't ignore that.
Yes, sir.
Now, what I'm contemplating is what's the proper punishment for you for this case? Is it 34 months, which is where you fall under a B for possession of methamphetamine based on your now elevated criminal history, or should it be something different? Well, I think it should be something different and something lower than 34 months.
Yes, sir.
And I think the appropriate punishment is 12 months in prison under a durational departure. I'm not finding substantial and compelling reasons to place you on probation and grant a dispositional departure. This is going to result in you serving. I think there are substantial and compelling reasons based on what's been presented here. Your candor to the court, your taking responsibility, having a plan, but I can't ignore the criminal history and the actions taken since the plea in this case. But I think 12 months is an appropriate sentence for that, so that will be the order of the court. You are eligible for 20% good time credit and are subject to 12 months post-release supervision. You do have 50 days of jail credit towards your 12-month sentence. In count 8 for the paraphernalia charge, I will order a 6-month controlling sentence and run that concurrent. For count 11, the registration offense.
Judge,
Yes.
that count is a class B misdemeanor with a max 6 months. You said 12 months.
I meant 6 months. 6 months on count 8, concurrent with count 1, or count 2 rather. 30 days controlling sentence on count 11, concurrent with everything else. So your controlling sentence is 12 months.
Yes, sir.
I'm not going to assess a fine. However, you will be ordered to pay the court costs of the case. I'm going to order you pay a $400 KBI lab fee, a $45 booking fee. I'll waive pursuant to State versus Robinson, reimbursement of bids application, court-appointed attorney's fees based on your incarceration and inability to pay. Since you will be ordered to serve this 12-month sentence in the Department of Corrections, any costs and fees will be likely sent to collections. You do have a right to appeal this sentence. If you choose to appeal, you have 14 days from today's date. If you can't afford an attorney to do an appeal, one will be appointed for you. As a convicted felon, you're not to possess firearms, and there are the loss of certain civil rights, such as the right to vote, until your sentence has been fully discharged. You may have a right to expunge these convictions from your record at some point in the future after you've completed your sentence and a couple of years have passed. Ms. Gillette, can you think of any sentencing related orders I've not addressed?
Well, no, we just asked that you remand her to the custody of the sheriff for transportation. And we wish her good luck in her future.
All right, Mr. Ambrose, anything further?
Nothing for me other than if I could have a breakout room with her real quick before we wrap up, I'd appreciate it.
All right, Ms. Livingstone, do you have any questions?
No, sir. Thank you.
All right, well, I hope after you complete this time, and if you get your good time credit, it won't be that much longer, that you then are able to enact the plans you have and can put all of this behind you.
Yes, sir. Thank you.
So good luck to you. We'll place you in a breakout room now with Mr. Ambrose. All right, we'll go on the record in State of Kansas versus Terry Lynn Bogart, case number 25 CR 64. Would counsel announce appearances, please?
May it please the court, the state appears on behalf of state appears by Jill Gillette, County Attorney.
Joy K. Williams appearing by Zoom on behalf of Terry Lynn Bogart, who also appears via Zoom from the Greenwood County Jail.
All right, Mr. Bogart, can you hear me okay?
Yes, I can.
All right. A defendant's motion to set aside guilty plea has been filed with the court. We're here to take that up today. Ms. Williams, are you ready to proceed on your motion?
Yes, Your Honor.
And Ms. Gillette, are you ready to proceed?
We are, Your Honor.
All right, Ms. Williams, go ahead.
Your Honor, I had filed a motion to set aside guilty plea. Along with that, I had filed a verified affidavit for Mr. Bogart in support of his motion to withdraw a plea. He is here today and obviously can testify and answer any questions regarding that affidavit. My understanding is the night before he was set to have jury trial, he had been prescribed some medication called Lisopril that is to manage high blood pressure, but they had him at a dose that apparently was way too high for what he needed. One of the side effects of Lisopril is low blood pressure to bring it down, but this medicine brought it down to where the bottom number was reading in the 40s, dangerously low. They started to take him to the hospital, but then called him back and didn't take him to the hospital. Instead, they had him in a room at the county jail, and the nurse had one of the deputies monitoring Mr. Bogart's blood pressure every 15 minutes. Because of that, he didn't get any sleep. His blood pressure, and he knows it was reading in the 40s because he could look over and see the readings. And so when he came into court the next morning, he was suffering from sleep deprivation. He was still feeling the effects of the medication. I will tell you, Lisopril, the side effects can be low blood pressure, lightheadedness, headaches, dizziness. And so Mr. Bogart was under the effects of having too much of this medication, and instead of just managing his high blood pressure, it brought it down to dangerously low levels. And so he had wanted the jury trial. He was presented with a plea offer, and he followed what his attorney advised him because he did not have sufficient mental capacity at that point to understand the plea, to have the presence of mind to really evaluate the plea and to basically argue against the plea. So, Your Honor, at this point, I would defer to my motion, defer to Mr. Bogart's affidavit, but I believe at the time, because of his physical and mental situation, he was not able to sufficiently understand, he had diminished mental clarity. He was not able to understand his rights. He was not able to contemplate the plea appropriately, and he should be allowed to withdraw his plea. Since he's asking to withdraw his plea prior to being sentenced, I believe the court has a lot more discretion to allow him to withdraw his plea and to give him a chance to reestablish his right to jury trial. So I'd ask the court to allow that to happen. Thank you.
Thank you, Ms. Williams. Ms. Gillette, what is your position?
Your Honor, my position is Mr. Bogart had been on that lisinopril dose for a while. He's known to he had caused issues with his health before. I can't tell you if he had anything, but he'd been on that dose, and it's not like it's a changed thing. His plea agreement and plea negotiations had been completed on November 20th, not the day of his actual plea. In fact, the plea agreement was taken to him on November 20th. There had been a want and desire to sign it on November 20th when Mr. De Hoyos came to meet with me. Then on December 2nd, we ended up entering that said plea. Mr. Bogart had been given a copy of that plea agreement November 20th. He had plenty of time to go over and look at his plea agreement. And there had been an intent for him after court to plea, and he kind of waffled a little bit on the 20th, but then wanted to plea before December 2nd. I don't believe this was a last minute decision on December 2nd. He had that plea with him since November 20th when it was printed and taken in person to the jail by Mr. De Hoyos after he had met with me here. The court went over on the record with Mr. Bogart, the plea issues. It was a very in-depth conversation. He agreed that he had signed it, that he had time to talk with his attorney and was happy with his counsel. And we had visited about that. He was asked if he wanted to make this plea at the time, and he did. The court asked him about the lengthy plea agreement. It's on page 6 of the trial transcript, and he did in fact sign it, and he said, yes, I have, and that he's had the opportunity to review the document, and that he had all of his questions answered about the document, and gave his name and that and all of his information on the record, as well as in the plea agreement that was written. The court went over his rights with him and went over all of that same stuff with him that is in his plea agreement, and talked about the level 7 person felony, and that if he had 2-person felonies or more in his criminal history, that he could fall into the presumptive prison grid. Again, this is not something that was quick on the second. It was something that he had in his possession for a significant amount of time. So that was all stuff that had been discussed and gone over. The court went over all of those different issues with him on the record, as well as it being in writing. He was, it was talked about on, that he was alert and intelligent, that he had answered all the questions correctly. He'd said he was not in a position where he was under the influence of anything and was in his right mind. That was all information, and that he was not under the influence of any drugs. And so I believe if he's got buyer's remorse all of a sudden, then it's buyer's remorse. But I do not believe that he was not appropriate on that date and time. And I believe that he knew what he was doing, especially based on the fact that he had a plea agreement in his possession from November 20th after court through the date he entered the plea.
Judge, that was a period of time, November 20th to December 2nd, when he was on the Lissopril. And if you want, I would invite my client to give testimony as to the effects of the Lissopril and the sleep deprivation he was under the day that he rendered this plea. I realize the court made a thorough record. That notwithstanding, Mr. Bogart did not have the mental clarity to be giving and was not able to give the appropriate answers or the appropriate attention to the plea. So, Your Honor, if I may, I would like Mr. Bogart to describe how he was feeling that day when he rendered the plea.
All right, Mr. Bogart, could you raise your right hand? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, go ahead, Ms. Williams.
Mr. Bogart, you were present in the courtroom, I believe, on December 2nd, 2025, and you rendered a plea in this case, correct?
That is correct.
Now, the night before, were you able to get any sleep?
No, I was not.
Okay, and could you tell the court why you did not get any sleep the night before?
I was taken into a small room, which they call a blue room here at the county jail. I was put under observation to monitor my blood pressure because of medication that I was on for high blood pressure. Because they were giving me 40 milligrams of this medication to keep my blood pressure down. But it was too much. I was, at that time, I was on this. I was sleeping anywhere from 16 to 18 hours a day. I had other inmates that were constantly coming in, waking me up to make sure I was all right. They would come in to make sure I'd get up to eat, stuff like that. I mean, I even walked into one of the walls. I'd walk into the bars and stuff like that. I couldn't even hardly walk straight. That's how bad I was incapacitated and incapable of
Mr.
getting
Bogart,
around.
what you're describing now, is that in the days leading up to the night before the plea?
Yes.
And that was the effect that this dose of medication had on you in, let's say,
Yes.
the 10, 14 days prior to you coming in to render the plea in front of Judge Crum?
Yes. I
Okay.
was constantly like that. I mean, they started me off with 10 milligrams of this medication. That was only for 3 to 4 days, and then they jumped it right up to 40 milligrams. And I mean, and I kept telling them, I even put in a request to the nurse, said, look, I feel I'm getting too much of this medication. I'm not coherent. And she, oh, well, you got to give your time to adjust to this. And I mean, this was at least 2 weeks into having taken this medication.
So
She
when they
wrote-
jumped your dose up to 40 milligrams, is that when you started sleeping an excessive amount and walking into things and not being clear-minded?
Yes.
Okay. So let's go to the night before the plea. What happened that caused them to put you under observation?
I told another inmate, I said, look, I need to go to the hospital or something because I'm not doing good. I mean, I'd lost weight. I was down to like 104, 105 pounds. I was just delirious. I wanted to go to the hospital. I needed to see a professional. That I didn't feel comfortable with the so-called nurse that was here because didn't seem to be very confident in
Well,
doing what she was
let's
doing.
not get into that, but you were feeling pretty sick that night, right?
Yes, I was.
Okay. Did they start to take you to the jail or to the hospital from the jail?
Yes, they escorted me down and out the back door, out through the front door of the jail, and I was just getting ready to get into the patrol car to be taken to the hospital when there came a call saying that they needed an officer for assistance. So they brought me back up into the jail and put me into what they call a little blue room. And the nurse came back to the jail here, and she said that I could be monitored there. And she took the DO, the detention officer, and explained to her how to utilize this little battery operated pressure machine, and that she could take care of that and every 15 minutes monitor my pressure to make
So
sure
they
that,
keep you up during the night, all night to keep taking these constant readings?
yes, they would do it every 15 minutes. They would come in and
So
put
you
that.
were, go ahead, sir. You were observing some of these blood pressure readings. What's some examples of the readings that were being taken?
Well, some of them would be like 140 over 120 or something like that. I mean, some of them dropped all the way down to as much as uh, you're asking me to try to remember numbers. That's hard to remember.
Well, I believe you had stated that your
I mean,
blood pressure, your
it
lowest.
dropped down to like 159, 158 at the bottom end of a lot of it.
Okay. I thought that it had dropped dangerously low at one point.
Yeah, because I mean, the nurse said that if it had dropped below 160, that they were supposed to contact take me to the hospital if they got below that.
Okay. And are you sure of that number, that 160, or was it a different number?
No, it was definitely that number. If it got below
Okay.
160, because she emphasized that, because if it did, they would have to put an IV of some sort into me to bring my pressure back up.
Okay. So, but your blood pressure was, the numbers were reading at such a point that they were concerned enough that they kept you up all night with the possibility you were going to have to go to the hospital.
Yes.
Okay. So you didn't get any sleep that night?
No, I did not.
Okay. Were you feeling any headaches, dizziness, lightheadedness?
Yes, I was definitely really lightheaded. I mean, as far as uh, being able to sleep, I couldn't get any of that. Like I said, every 15 minutes, it was constantly putting that band around my arm, taking my blood pressure. As far as keeping any kind of conversation, that wasn't quite capable of keeping any kind of real conversation going.
Okay. So the next morning you were taken to the courtroom, correct?
Yes.
Okay. And did you feel like you understood the plea and what you were doing that morning?
Well, by what was explained to me, that it was going to be a plea agreement, and that the attorney told me that this was going to get me no more than about 6 months at the most in prison, that I would be out as long as I signed the agreement to it and all this. And I said, well, are you sure of this? And he said, well, that's about what it would amount to, that I'd do 6 months at the state prison and I would be out. And that's all I
Were
had to
you
do
still
was sign it.
were you still feeling the effects of the sleep deprivation and the dizziness and lightheadedness?
Yes, I
Okay.
was.
Were you mentally clear that morning?
Not completely, no. No, I was not. As a matter of fact, I was even having problems walking from the jail over to the courthouse. I mean, the head jailer that escorted me over there, he kind of had to slow down to keep, because I couldn't keep up with him as fast as he would go off.
Okay, thank you, Judge. I have no further questions.
Thank you, Ms. Williams. Any questions for Mr. Bogart, Ms. Gillette?
Mr. Bogart, you didn't have any objections to your sentencing on March 26th of 2026, did you?
Not with what I was told by my so-called attorney that was supposed to be defending me.
Okay. And on March 26th of 26, the only reason your sentencing was moved out was for a correction for the PSI to change the 2 charges, right?
I mean, I didn't understand what was going on with that. I didn't understand what was going on with any of that.
And the only thing that you were concerned about in March was whether or not you were going to get a departure. Is that correct?
I mean, I didn't even understand why that was. I mean,
and then in April was when you decided you were unhappy with Mr. De Hoyos, didn't you?
yeah, because he wasn't doing, he didn't seem to be wanting to do any kind of defense for me.
Is that and you had changed your mind by then and wanted to withdraw your plea?
Mm-hmm.
But you didn't want to withdraw your plea on March 26th of 2026, did you?
Yeah, I mean, I was trying to get rid of him then. I told him that he wasn't getting me any information. He wouldn't.
Mr. Bogart, I need you to answer yes or no's or directly to the question, okay? You did not complain about Mr. De Hoyos in court March 26th of 2026, did you?
No, because he wouldn't.
Ben wanted to have your sentencing done that day, but there was a problem with the PSI. Isn't that correct?
I believe so. I mean.
Okay. And then in April, you were upset with Mr. De Hoyos, and then you didn't want to be sentenced.
Yes.
Okay. And now you're bringing up medical stuff here in August, but the reason that you wanted to withdraw your plea was you didn't like Mr. De Hoyos in April.
No. Because yeah.
No further questions, Your Honor.
All right.
Your Honor, I'm sorry. I was just going to point out that on the record, April 16th, Mr. Bogart stated that he was not in the right mind frame. He had overdosed on medication, was sleep deprived. That came directly from the transcript of the April 16th, 2026 hearing. So he was not just complaining about Mr. De Hoyos, but the fact that he was not in the right state of mind. So I just wanted to clarify that for the record. And that's in my motion also, but you can also find it in the transcripts that were produced for this hearing.
Okay, that was the April, and then there was the March. We attempted to have him sentenced before that on March 26th, but there was an issue with PSI.
Correct. And I don't have that transcript in front of me, but as I recall, that was mainly a conversation between the court and counsel, not Mr. Bogart. So I don't think Mr. Bogart really had much of an opportunity to talk about the status of the plea.
Okay. Anything further in argument of your motion, Ms. Williams?
Your Honor, I would just say that the testimony is that for several days prior to this plea, he was feeling the bad side effects of this medication, walking into walls, sleeping excessively, not eating. He had no sleep the night before the plea, which can't be good for anyone. He was not mentally clear. He has stated that he didn't understand what was happening in a lot of these court proceedings. So, Your Honor, I don't believe the court can say that he understood what he was doing, and I believe we have shown good cause to withdraw this plea. Thank you.
All right. Thank you, Ms. Williams. Right. I was the the judge on the case back on December 2nd, when we were scheduled to start jury trial that morning. I recall being advised that Mr. Bogart did have some sort of a medical issue the night before, but Mr. De Hoyos was going to go talk to him to see where we're at on trial or plea. And after a conversation that had occurred between Mr. De Hoyos and Mr. Bogart, we went on the record, and I was advised there's going to be a plea being taken. I have a very standard, thorough line of questioning I go through on any plea with any defendant, and there was a transcript made of that December 2nd, 2025 hearing. I do have that. I don't recall any observations of Mr. Bogart during the initial part of the proceedings that would have led me to believe that he wasn't in a proper state of mind to proceed. Otherwise, I wouldn't have. But let me go through some portions of this transcript. Right, the attorneys announced what the plea agreement was going to be. Then I indicated that a copy of the written plea agreement had been presented to me that had Mr. Bogart's signature. Mr. Bogart was asked, "Is that in fact your signature?" He responds, "Yes, it is, Your Honor." Mr. Bogart was asked, "So, Mr. Bogart, do you wish to enter the plea that's been announced here on the record?" Mr. Bogart responds, "Yes, I do." Mr. Bogart was asked, "All right, and you've read through this rather lengthy document that sets forth your rights and what the plea agreement is?" Mr. Bogart, "Yes, I have." "And you did in fact sign this?" "Yes, I have." "And you've had an opportunity to review this document with your attorney, Mr. De Hoyos?" "Yes." "Was he able to answer any questions you might have had to any of the terms in this plea agreement?" "Yes." Then I started going through kind of the standard list of questions that I asked. Mr. Bogart was asked, "Is your plea being made freely and voluntarily?" He responds, "Yes, it is." "Has anybody made any threats or promises other than what's in the plea agreement to get you to enter into this plea today?" "No, sir, no." "And you have had legal representation during the course of these charges, is that correct?" "Yes." "And if you've had questions about any of the legal terms or concepts, you've been able to address those with your attorney?" "Yes." Then the process of jury trial was gone over with you. You were able to answer all of those questions. Going through all of the trial rights, appellate rights you would have if convicted, went over all of that, explaining that you give up your right to present defenses you may have had to any of these charges. You said you understood that. You were asked, and if at any time along the way, Mr. Bogart, you need to visit with your attorney, just let me know. But right now, I'm just going over the possible penalties that can be imposed. We went over the sentencing grid, all of the possible penalties that could be addressed or that could be imposed upon you as based on the conviction. Went through each of the charges and the possible penalties on the grid, possible fines. You were asked, "As you sit here today, do you have a clear mind?" You answered, "Yes, I do." You were asked, "Are you presently under the influence of any intoxicating liquors or drugs?" Mr. Bogart responds, "No." "Have you had plenty of time to discuss this case with your attorney, Mr. De Hoyos?" Mr. Bogart responds, "Yes." "Do you need any more time to visit with him about the matters you and I have just discussed?" Mr. Bogart responds, "No, I don't." "Keeping in mind the matters we have discussed, is it still your wish to plead no contest?" Mr. Bogart, "Yes, it is." The factual basis was gone through by Ms. Gillette. The court accepted the plea. I made the observation, I find that you are alert and intelligent, understand the nature of the charges, appreciate the consequences of pleading no contest. I further find you understand the rights you're giving up by pleading no contest. Then you are found guilty. Mr. De Hoyos goes on after sentencing dates have set. Mr. De Hoyos states, Judge, briefly, just so the parties are aware, we spoke earlier today about any concerns of mental health competency for Mr. Bogart, and I want to be crystal clear that I have no reason to believe there's a competency issue of any kind. He hasn't demonstrated anything of concern here in court, but I also want to put on the record that I don't have any reason to believe he is incompetent or any reason despite this. Sorry, despite any anxiety he has getting to trial today. Which was consistent with my observations in court of Mr. Bogart as the plea was being taken. Now, looking at the written plea agreement itself, very thorough 7-page document. In this document on page 3 that Mr. Bogart signed, it indicates I will plead no contest to aggravated battery, level 7 person felony, and count 4 criminal possession of a weapon by a convicted felon, level 8 non-person felony. Then it states, I understand the joint recommendation of the state and defense will be the number of 34 months with all concurrent. That my behavior may affect my recommendations at the time of sentencing. All guns will be surrendered to the Greenwood County Sheriff's for disposal according to law. I will have standard costs and fees assessed by the court, including but not limited to court costs, booking fees, attorney's fees as assessed, KBI lab fees, and others assessed. This is a presumptive prison case. And that was in the written plea agreement signed by Mr. Bogart that he stated on the record that he had signed. The legal standard for withdrawing a plea under KSA 22-3210 is a plea of guilty or nolo contendere for good cause shown and within discretion of the court may be withdrawn at any time before sentence is adjudged. There is some case law that I reviewed regarding withdrawals of plea. One case that I looked at was State versus Bay 270 Can. Well, I don't have the full citation, but
Judges 270 Can 544 17 P 3rd 322. It's a 2001 case.
thank you.
You're welcome, sir.
Right. It goes through stating in evaluating a motion to withdraw a plea, the trial court should consider whether 1, the defendant was represented by competent counsel, 2, the defendant was misled, coerced, mistreated, or unfairly taken advantage of, and 3, the plea was fairly and understandingly made. Well, court finds that Mr. De Hoyos is competent counsel. He's has years of experience representing defendants in criminal jury trials and cases. 2, whether the defendant was misled, coerced, mistreated, or unfairly taken advantage of. Mr. Bogart was given time to read through a written plea agreement by Ms. Gillette's assertions. Mr. De Hoyos had taken that to him in advance. Whether or not that happened or not, doesn't change the fact that he had an opportunity to review that, read it.
Excuse me, Your Honor. You want to call?
You're not talking right now. The court doesn't find that the defendant was misled, coerced, mistreated, or unfairly taken advantage of. A thorough recitation of Mr. Bogart's rights and options were gone over with him on the record. He was given an opportunity to, if he had any questions or needed additional time, to visit with Mr. De Hoyos that the court would have given him that time. He didn't request any of that time. 3, whether the plea was fairly and understandingly made. The court finds nothing in the record that would indicate that that wasn't done. Again, all of his rights, options, all of the possible penalties were gone over thoroughly with Mr. Bogart, who by the court's observations was of clear mind and based on Mr. Bogart's own statements to the court that day on the record. So the court's not finding good cause shown to withdraw the plea, so the motion to withdraw the plea is therefore denied. Mr. Bogart needs to be sentenced. Are you all prepared to proceed to sentencing at this time?
Your Honor, being that I was secondary counsel on this and we've been working on this motion, I would ask for a little bit of time to go over this with Mr. Bogart. I don't know to what extent the PSI was gone over with him, so I want to make sure it's correct. So I'm asking for a little bit of time to do that. I also don't have a jail calc to know how much time he has served so far. So.
Let's have him sentenced September 17th. At 11 o'clock in the morning. Does that work for your calendar, Miss Williams?
Unfortunately, I will, hang on. No, I will be on an airplane that morning. I apologize. Are you available the day before on the 16th?
Possibly September 16th at 11.
I can do that.
September 16th, 11 o'clock in the morning. A sentencing hearing. We'll do that by Zoom.
Thank you, Judge.
Can I speak with Joyce, please? On a sidebar?
We can set up a breakout room. All right, we're in recess on Bogart. We'll set up a breakout room.
Well, ladies and gentlemen, that's all there is for the time being. There'll be more a little bit later. But for those of you who are eagle-eyed viewers, you will notice that right there at the very end was that was the moment that something happened in the Greenwood County Jail. And I don't know what it was, but that was basically the hearing where something happened. And those were out of order. So technically speaking, the young lady that you saw just beforehand came after I reorganized it. So it was nothing related to her. I can hopefully say. I think that's the case. I don't rightly know. I don't honestly know what exactly happened. Ladies and gentlemen, thank you so much for hanging out with me today. I do want to say a special thank you to all of my viewers who have been participating in chat, because you guys just rock. Renee Galloway, Great Granny, you guys get special shout outs. Especially Renee. This is like Renee's second live. And I don't know if I showed her enough appreciation for the fact that, hey, thanks for coming back. Come on back by tonight. I have some interesting stuff we'll be watching tonight. It's Judge Dad, 2 different cases. The first one is on May 4th. May 4th. The first one is on May the 4th. The second one is on May the 11th. So, come on by. This is a case where there was somebody who was helping somebody out with some home remodeling or something like that. There was a bunch of argument about quality work was done. Judge Dad decides he's going to go out, he's going to look at stuff himself, and he sets it for the next week. And then we get to see what happened the next week after that. And I just think it's a good little compilation to put together. I'm pretty sure we haven't seen both of them. We may have seen one part or the other. Y'all have to tell me tonight. We're not really 100% sure on this. I do know they both took place on Monday. So we don't often watch Judge Dad on Monday because we have Thursday night. Oh God, I hear the dogs. Hey, guys, come on by tonight. Watch Judge Dad with me. And tomorrow, I have a double feature from Washington State for Civil Sunday. And these are interesting. The one in Thurston County is one that a few people I think have mentioned and may be looking forward to. And the one in Cowlitz County, they're civil cases in Washington. Yeah, they're always interesting. Whether or not the regulations actually match the location or not, the attitudes are just next to none. Next to none. You'll see. Come on by. Check it out. For now, I am your lone wolf Oozle. I'm the guy who puts these little compilations together. I'm host and archivist. Now, I am out. And remember, only you can take a bite out of crime. Bye!